What are the initial steps after filing a petition for divorce? I'm Tulsa attorney James Worth. That's the question that we have. So once you get that divorce on file, what do you do? Well, the first thing is you want to get that served on the other party. You have to give them notice, and you have to do it in a way that is enforceable so that if they don't file a responsive pleading timely within 20 days of being served, then you can default them. So that's the first thing you want to do. Make sure that it is served. Additionally, you want to get your paperwork and everything together so that your attorney has the information they need to move the case forward, but you also may want to get some information from the other side. And that's a process called discovery. So you want to send out your discovery, whether that's requests for admissions, interrogatories, requests for production. You get those out. The other side has 30 days to get responses to those things back to you. If it is if children are involved particularly, but also if there's property issues, you probably want a temporary order. So you want to file an application for a temporary order hearing. You want to get that set for hearing in Tulsa County prior to getting a temporary order hearing. If there's kids involved, they want you to do the parenting plan conference. So that's something that comes after that. So you want to get service. You want to get it set for your parenting plan conference if you're in Tulsa County. You want to get it set for a temporary order hearing. You want to get your discovery requests out. You want to make sure you have all the information that you need should you have to put on a trial. And then once you get to that point, you should already have temporary orders in place. You're probably going to want to mediate before setting it for a trial. So those are the general steps that we kind of go through in order to push a case forward. Sometimes you may want to set it for a scheduling conference to get a scheduling order in place that sets deadlines for certain things to be done, such as sending out discovery, responding to discovery, filing dispository motions like a motion for summary judgment, and deadline perhaps to do mediation. A lot of courts and a lot of judges require mediation before trial. Some do not though, but if you request a scheduling order, you can have that include, if the judge approves, an order to mediate by a certain date. So if you're going through a certain situation where you've got a divorce, that is litigation. You're in court. If you don't work in agreement, then you're talking about evidentiary hearings. You're talking about rules of evidence, complicated stuff. You're probably going to want to have an attorney with that. If you want to talk to an attorney to get legal advice, you want to do that privately and confidentially. To get that scheduled with an attorney at my office, you can go online to makelawEasy.com.